Hey guys, in case you did not know, this is a real lawsuit. It's not time for jokes or funny memes. This is actually a real lawsuit, and it is going to get far more real now for the Alexandra character, also known as her persona, Denims. And I'm sure that she is finally realizing that, holy shit, I've been sued if she has not already. So she's kind of made some jokes about it and even re-uploaded the infringing video without the shout out to Amazon Prime subscriptions. And this is three major updates today. I think I'm going to tackle the longest one today, and I'll leave the 22 and 24 for a later date. So we're going to tackle 23. 23 is the civil pre-trial schedule in trial order. So here, the scheduling conference scheduled for 9/26/2025 is hereby vacated. The pre-trial schedule governing this case is set forth in the right column labeled court order. So this is actually a very good learning experience for people who want to be lawyers, or if you ever get sued. The goal of the judge and the court system at this point in time is to have the plaintiff and defendant agree as much as possible. And this is like in good faith. They should work together, figure out a schedule, figure out who the witnesses will be, figure out the depositions, the interrogatories, the discovery period. And often, in terms of working together, the more you work together, the more you're likely to settle. So there is a ADR order. ADR is for mediation, arbitration. This is often done with retired judges. So it is somebody who's seen a lot of cases. When we went to arbitration, it was a retired judge who worked in that exact court, and then he retired, and then a new judge replaced him. So our case was going to be decided by the judge who replaced the judge that we were doing for arbitration. Very knowledgeable, and they've seen many cases before. They can tell you the best outcome, the worst outcome, and what they believe the outcome of this case will be. So facts and expert discovery cutoff, discovery motions. This will also govern timelines and deadlines. If you've ever been sued before, or if you, for instance, ever filed for a patent or copyright, you understand that deadlines are deadlines. They are hard deadlines, and then there are soft deadlines. There are flexible deadlines, and then there are very, very unflexible deadlines. So discovery motion, it is going to be very interesting to see text messages and maybe conversations between Denims and Casey Tron. I'm sure that has happened. Conversations between, in discovery, one thing that I didn't think they would do is I'd had to turn over almost everything for 2 years. So it is very intrusive. It does take a lot of time. When your job is streaming, I actually talked to a very large YouTuber who's dealing with a copyright issue right now. I told him, hey, your job is to make YouTube videos. This is not your job. This is not really your battle. It can be very, very burdensome, not just financially, but the time. And we're going to go over the time. You just look at all these steps and all the things that have to happen. This is going to take a lot of time, even if you have a lawyer. So this is ADR. Settlement proceedings, alternative dispute resolution deadline. Pursuant to local rule 1615, the parties must participate in settlement conference ADR procedures. This is true not just for Denims, but also for Casey Tron and also for Frogan, that the court is going to say, hey, you're going to pay. And these mediators are not cheap. Again, they're retired judges. So let me go over the expenses. You have your lawyer, they have their lawyer. There might be a paralegal taking notes, a secretary, the judge, or let's say you hire a retired judge. They don't come cheap. Our mediation was $2,000 a party. We had 3 different parties, so it was $6,000 total over 2.5 hours. So you're talking about probably $2,000, $1,500 an hour for that media. Now, again, you also get to rent out a pretty cool law firm, right, that everyone agrees to go to that day. So it's a really nice law firm, and they provide you nice lunch as well. So there is fringe benefits, I guess. But during that time period, you're also paying your lawyers. Plaintiff pays their lawyer, defendant pays their lawyer for the whole 2.5 hour, 4 hour, 6 hour, 8 hour. It really depends on how close you guys can get. Typically, you're just going to talk about ranges. I would settle for this range. And then the plaintiff says, I settle for this range. Defendant says, I settle for this range. And the judge does not disclose either of the two ranges to each opposing party, but tries to figure out, is there kind of a middle ground where we can just sign a paper and it goes away. You can request for additional audio visual. This is for depositions. It costs more money. These are court approved. Again, anytime you have this court approved expert, court approved videographer, court approved transcriber, because they are specifically just doing this, they cost a lot more money. So these are people trained to do depositions, to do videos of your deposition and so on. And, they're pretty nice. I never really had an issue of anyone, they were all very professional, very nice. And it was I wouldn't call it a good time, but everyone was in a relatively good mood because of the professionalism that's going on. So everything is expensive. Of course, they don't come for free. They cost money. And like I said, anytime a person is an expert witness, specifically doing only legal cases, they're going to cost a boat ton of money. No matter if they're forensics, a medical, it doesn't matter what type of witness they are, they can charge a lot of money because the court has already used them before. And the idea is that, hey, this person is court approved or has been used in many cases in this similar court, so we can trust their opinion. Right? So the judge may like that. And a lot of times they're friendly, they talk. There's a saying, you don't shit where you work, right? This is exactly true. The plaintiff and defendant lawyers, they have to be friendly to each other because they could see each other again. Maybe they one time were plaintiffs versus defendants, the next time we're defendants versus plaintiffs. Maybe next time we're both on the same side, the lawyer's on the same side as the other lawyer. They had to work together to figure out. And you never know. The same with judges. You never know when. So it's always good to be polite. It's always good to be courteous. It's always, there's professional courtesy. Here we have opposition to motions in Lime, joint proposed FP. Like, you see this stuff and it just gives you a headache, right? So I'm a lawyer. I look at this stuff and it just gives me a headache. It just I have flashbacks of when I got sued and how not fun this was, right? Because we had to do all this stuff. I had experienced it. We settled or we resolved our issue a day or two before trial. If we had not settled that day, we would have gone to trial or that weekend. I think it was a Friday we had to make a decision. And I think Monday was a trial or something like that. Look, it is not a fun time to do all these things because if you miss a deadline, you're effed. If you miss let me just say this. It's not as easy as you would think. Because there's multiple timelines, the timelines change, and the witness timeline. It is not easy getting everyone together on a timeline because it's not. So if you have a witness and you want to depot your witness, the opposing counsel has to also have the opportunity to depot that same witness. And if there's multiple parties in stake, then maybe that party even has their own lawyer as well. So you're dealing with multiple lawyers. I mean, what if Casey Tron is a witness for either Ethan or a Denims? This stuff is going to take a long time. And you look at this stuff, you look at 35 days, 28 days, 21 days, right? Look at jury instructions that they have to agree upon. And so it's a very complicated dance that will consume Denims. Denims is not going to be very happy. So he's going to be exhausted. A lot of this stuff, like interrogatories, for instance, which is the very beginning of discovery, before your deposition, and then obviously depositions, these take time to prepare. It would be very foolish for you to go there and not ask your attorney to look it over or to do some type of training for the depositions. The interrogatories take time. Those are questions they answer to you, that they send to you, and then you have to answer these questions. And then if your lawyer has any questions about why do you answer this way, maybe it'd be best then you have a conversation about that. This stuff is going to take hours, days, if not weeks of your time. And that's trial. Like, even the best attorneys, they can only save you so much time. At the end of the day, you have to answer your interrogatory. They're not your attorney's interrogatories. They're yours. You have to do your deposition. They're not suing your attorney. They're suing you. And there's a lot more stuff involved. So when I look at this, it's a very long document. How many pages are we looking at? It's a very lengthy document. I just get headaches because I had to do this. Like it is, you're constantly just getting emails from your lawyer. Do this, do that. Did you do this yet? Did you do that? No, do this. No, we need to do this now. And it's not a good time because every time your lawyer sends you an email and you need to respond to it within a timely manner, otherwise you're going to be screwed. And you may not be screwed today, but you may be screwed tomorrow because there could be something else, a different motion, and so on. What I want to say here is this is not a joke. This is not something you laugh at or have fun with. Like a lot of times, like Carl Jobs, I think Destiny for the most part, they view this as like a fun thing they share with their subscribers. I can tell you right now from firsthand experience, it is not fun. It is not fun. It is not a good time, and it is going to be. It's only going to get worse and worse and worse. Right? Proposed findings of fact and conclusion of law. Trial exhibits. Trial exhibit that consists of documents and photographs must be submitted to court in free ring binders. The parties shall submit to the court free sets of binders. Yeah, like the way it's just like so detailed in what you need to do. And if you submit 2 sets of binders, you're effed. Then none of the binders go into evidence. I'm not joking about this. In court, they are very, very specific as to what they want to see, the format they want to see it. And more to the point, it's just common courtesy. It's, hey, everyone's done this for a long time this way. And that's what's happened here. So back to my analysis as to this case, it is going to be a very long, very brutal case. It is going to be a case where nobody's going to have a ton of fun. No one is going to have a ton of fun doing this, publishing exhibits. Like, does this sound fun to you? It's like, it's like a project that you didn't have to do, but you don't really get extra. Like, being sued is no fun. And having to do all this shit, and here, mind you, the less you do, the more your attorney is going to do, and the more billable hours your attorney is going to have. So there's no win-win here. So if you want your attorney to do more work, great. You are going to find out that you're going to pay a lot more money for that privilege of having your attorney do more work. I really look at this and I say to myself, holy shit, that was a terrible time for 4 years. This stuff is so boring. Meeting and conferring, closing arguments, post-trial briefs, bench trials only. I do think there's got to be room to make a better type of system, a legal system, because like I said, you don't even get to trial without spending a ton of money, maybe unnecessarily so. And even settlement is by far the best. So people should not be afraid to settle. People shouldn't be, I'm anti-settlement. Let's make some more Billy Mitchell videos and attack that guy again. Like that's what I don't really get is settlement is always the best option for both parties. It saves you a hell lot of legal fees, and it saves you more time. Deposition, we didn't even get to that, but interrogators, deposition, discovery, they take a long ass time. I'm not talking about like a fun time. It is them asking you all types of really weird questions that you have to respond to, even if you don't feel it's relevant. Eventually, it can be striked on later, but you still have to answer the questions, and they can be very, very. In my deposition, they kept asking if I was like an alcoholic and how much alcohol I drink, and I haven't drank. I do not drink alcohol. I have not taken a drink of alcohol since I graduated law school. Yeah. So really, really bizarre. Something where I would definitely, you wouldn't wish this on your worst enemy, to be quite frank with you. It is a very scary thing to be sued. It is a very, very scary thing to have to deal with a lawsuit of this nature. Nobody is going to have fun here. It is very, I mean, maybe the lawyers get fun, right? I mean, maybe the lawyers who are getting paid are like, wow, yeah, I got paid a ton of money. Let's make some more money. But neither defendant or plaintiff is really going to, they're just not going to have fun. This is not a fun experience. This is a very brutal experience that will take possibly many years. And even if it takes settlement, always settle. Always settle. That's what I would say. Settlement is always a winning solution. It's going to save you a lot of money, a lot of time, and at the end of the day, everyone wins, right? In settlement. Even the lawyers, they get paid a little bit of money. So it's real. This lawsuit is real, and it's going to follow a very strict standard. And it will be an eye-opening experience for somebody who has not. The biggest advantage that somebody has who has been sued, like Ethan has been sued before, is they understand just how difficult the legal process is, and they can mentally prepare for it. Denims has no idea what is heading her way. This thing will consume her life. She will appear more tired on streams or do less of them, I assume. You can see how it's affected Destiny's life, and the case in Destiny, it wasn't even like that big of, I mean, it was big accusations, but because of the lawyer fumbling stuff, it just should have been over already. But Destiny's made it more difficult than he has to, and that's kind of on him, right? So anyway, let me know what you guys think on the lawsuit. There's 2 more important documents about AD. We'll talk about ADR, what the experience is like. Obviously, I had to do ADR, and yeah. Anyway, bye guys. I'll give this video a like if you like it, and a comment to help the algorithm.